Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So today on the podcast, we have another recommendation from my good friend Chad on Twitter, and he recommended The Queen and Armitage, which is another Ontario case coming from the lower courts in Ontario. It's coming from the Gladue Court again, out in Toronto at Old City Hall. And this case actually has a couple different factors used in it, but I think the through line that Chad told me was he really liked this case for the plain language analysis that the justice undertook when crafting and writing this decision. Because as we all know, the law is horribly inaccessible for use of language.
Yeah, I mean, as I say, if there's one thing I've learned in trying to record these decisions, is that like lots of the decisions written before 1985 are literally unreadable because they're just like giant, bloated one sentence things that go on for paragraphs and paragraphs, and it's all sentence fragments, and it's not meant for the public to read, right? Whereas like I would say with Chief Justice McLaughlin at High Court there, at the Supreme Court, there was a huge shift towards writing things in a way that is actually understandable when she got to the Supreme Court. And I find all her decisions much more accessible than decisions by previous justices, obviously with all due respect. And it's good to see that a lot of the lower court judges are really trying to push things forward in an accessible format that is actually of use to the public, right? If the law is for the public and the public can't read it, that's a problem.
Yeah, and in this case, it's Justice Nakatsuru, that's Justice Nakatsuru from the Gladue Court up in Toronto. Mm-hmm. And in writing it, the judge themselves notes the fact that we are all, as actors within the system, we are all guilty of not using plain language. And it is actually difficult for us to learn how to use plain language in our writing, especially because we come to rely on the way cases are written. I remember, as like a little anecdote from like 1L, I wrote a memo or something for legal research and writing, and I got lambasted for it because I was like, no one can understand this. It's like, but this is all that I know because I've only read cases from 1942 so far. Uh-huh. But that's kind of the point, right? It's becoming a matter of unlearning a bit of legalese and relearning plain language or plain English because I forget it all the time. I mean, I use overly complicated jargon and language when I don't need to.
Oh, yeah, definitely. And I think a lot of the times, I always say that if you can't explain something in plain language, you don't really understand it that well. And I think that that's a lesson the law can definitely sort of learn as they go forward. And I know there are places that have been making huge pushes towards plain accessible language in legal decisions, especially in parts of law where there are so many self-reps, like family law, or in, like a social benefits tribunal or the landlord and tenant board. Places where there are many self-reps and more self-reps than represented parties, there's absolutely no reason why these things shouldn't be done in plain language. And the AODA, the Accessibility for Ontarians with Disability Act, has information online about how to make things in plain language. Like, it's not like the means of doing this and the methods of doing this aren't out there. It's just the law tends to, sometimes we like to think we're very important and we don't like the idea of making the law more accessible and for everyone. And I think that, luckily, I think those attitudes are shifting, but it's hard. It's hard to overcome sort of, generational preference of inaccessible language.
Yeah, absolutely. And I think that's what's really good from it. And even the judge acknowledges in this case that it's not easy, especially for some of us who have been in practice for a very long time, judges included, because they've had to be counsel for at least 10 years before they could be nominated for the bench, right? So it's a lot of unlearning, and I think giving credit where credit is due. And I think even though I'm going to say it again, I think I'm going to quote just one little piece of the case here. The justice says, "I believe that this is very important for judges to do in every decision." And I think if if anything, that's something that we should all take away from this case. And it's not just judges, it's what we submit to the judges too. So anyways, guys, I hope you enjoy this case. It's definitely a fun read for us because it's in plain language. So I hope you enjoy. The Queen in Armitage. Heard before Justice Nakatsuru on October 30th, 2014. This case was heard in the Gladue Court at Old City Hall in Toronto. Jesse Armitage is a troubled man of Aboriginal heritage who was sentenced by me a number of months ago. At the time I gave my decision, I said I would draft and release a written decision. This is that decision. Before I get to this, I would like to make 2 short comments. First of all, I want to say something about the style of this decision. For those who have read some of my past judgments, the reader may notice a change. For Jesse Armitage, I have tried to say what I wanted to say in very plain language. I believe that it is very important for judges to do it in every decision. However, judges often do not do a good job of this. I would describe myself as one of the worst sinners. As lawyers first and then judges, we get used to using words that are long and complicated. This only muddies the message we are trying to say. That message is very important when it comes to passing a sentence on an offender. That message is clear and even more important in the Gladue courtroom. I say this because in the Gladue Court at Old City Hall, accused persons who share a proud history of the first people who lived in this nation not only have a right to be heard, but they also have a right to fully understand. Their voices are heard by the judges, and they must also know that we have heard them. I believe that the accused persons who have been in this court have a good experience in this. This is something that they have come to appreciate. This is something they have a right to expect. I know that all accused, whether they have any Aboriginal blood or not, should have this right. Judges struggle to make sure they do. However, when judges write their decisions, they are writing for different readers, different audiences. Judges write not only for the parties before them. Judges write for other readers of the law, lawyers, other judges, the community. In this case, I am writing for Jesse Armitage. The other thing I wanted to say is something about our Gladue Court. This court was established in 2001. It was the first court of its kind in Ontario. Since then, it has matured. It is well respected. There is much cooperation between the Crown and the defense. The court applies the principles set out by our highest court, the Supreme Court of Canada, in the case of Gladue. We try to be faithful to those principles in every case. I admit the case of Jesse Armitage has been a challenge for me. The proper application of those principles has not been easy. Jesse Armitage is a 29-year-old man and single. His Aboriginal ancestry comes from his mother's side. Valerie Armitage is a member of the Anishinaabe community of Dokas First Nation, located southeast of Sudbury. Mr. Armitage has found himself in a pattern of minor criminality that he is unable to escape from. He has come forward and pleaded guilty to many criminal offenses. They are mainly property crimes and breaches of court orders. Mr. Armitage committed them over a period of a few months during the end of the year 2013 and into the spring of the following year. It is not important for my purposes to outline the facts of each offense. There is a sad and bleak repetition to what he does. Mr. Armitage has a plan that he uses. Sometimes it works, sometimes it does not. He goes into open businesses, sometimes through an open back door, sometimes through the front door. It could be a shop or a restaurant. He heads to the back to see what he can steal. Sometimes he finds a staff change room. There he grabs whatever is not locked up and of some value. If he is ever stopped by someone, he makes an excuse like he was looking for a washroom. One time, he threatened someone when confronted. During these offenses, he has been on probation or bail. He has been breaching these court orders during these crimes. Jesse Armitage has a criminal record. His offense started while he was still a youth. The crimes are usually the same. He has spent time in jail, received probation, and has been given conditional sentences to be served in the community. The sentences have not rehabilitated him. They have not helped him. They have not deterred him from committing the same offenses. They have not stopped his crimes. When he pleaded guilty to the charges, I had little idea about who Jesse Armitage was and why he did what he did. He is a large man, boyish in face, a face fringed by dark curly hair, and very quiet. He looks a lot younger than his age. I know his mother cares for him. His mother has attended court for him. She was supportive. She spoke one time to me in court about him, about her fears and hopes for him. She bailed him out. Closer to the date of the sentence, she did not come for him. This is not surprising because her son did not change much. He continued to reoffend. Miss Feinberg, the assistant crown attorney, and Miss Kelly, Mr. Armitage's defense lawyer, were incredible. They understood the problem. They worked together to try and get a solution. Although their position regarding the sentence was not the same, they cooperated to get as much information as possible on this Aboriginal offender. So, as I told Jesse Armitage on his sentencing day, we started this journey together. It was not one without its bumps along the way. It was also long. There were a number of adjournments. There was much investigation. Throughout, I tried to reach Jesse Armitage. Sometimes I felt I had some successes. There was sometimes a smile of understanding on his face. Other times, I just saw frustration in him. I know he did not fully agree with all the delay. I know he did not always agree with what was being done to fully be ready for the sentencing. Some days he just wanted to get it on with. What was done? The law says for Aboriginal offenders, it is the duty of the sentencing judge to get as much information about the offender. I have, with the help of the lawyers, tried to do so. A pre-sentence report was prepared by probation. A Gladue report was prepared by the Aboriginal Legal Services of Toronto. A psychiatric report was prepared by the Centre of Addiction and Mental Health. I will try to summarize what was said in these reports. When the pre-sentence report was ordered by me, I frankly told Miss Kelly that I had expected it would not be positive. What else could one expect in light of the numerous convictions for failing to comply with probation that Mr. Armitage has on his criminal record? That expectation turned out to be correct. The report was not positive. The probation officer writing the report had supervised Jesse Armitage on 6 probation orders. He remains on probation until 2015. The officer conceded that she had tried all available services for him that probation could offer. He had been encouraged, supported, and provided with referrals in the areas of education, employment, mental health, substance abuse, and personal counseling. To put it simply, in the probation officer's eyes, Jesse Armitage just failed to follow through with any of it. Specifically, the officer provided him with counseling options that was specialized to his Aboriginal heritage. When asked why he did not follow up with these, Jesse Armitage said, quote, "I don't know. I don't really like to do those things," end quote. In the appointments with the officer, he did not give the probation officer much insight into what he was thinking, feeling, or wanting for himself. He seemed uninterested in changing. The probation officer did raise the concern that there could be a possible underlying mental health problem that had not been diagnosed. She recommended a mental health assessment. But, to date, Mr. Armitage has not been cooperative with any process suggested. At the end of the day, it is fair to say the probation officer was at a loss as to what could be recommended for him. The pre-sentence report also outlines Jesse Armitage's background. I will now talk about this more when I turn to the Gladue report. The long and detailed Gladue report was very helpful in telling me about this. Jennifer Bolton, the Gladue caseworker, has written a very good report. Such reports are useful in telling a judge about the particular nature of the offender's Aboriginal ancestry and how being an Aboriginal person has affected his or her life circumstance. The report talks about how the offender has been influenced by his or her Aboriginal ancestry, whether specifically in his or her life, systemic factors, or historical reasons. In other words, there are many ways Aboriginal ancestry can affect an offender's life and can be telling as to why he or she committed the crime. It does not have to be a direct cause, like clear discrimination. An example of direct discrimination would be the loss of work or opportunities for work because the offender is Aboriginal. It can also affect an offender if being Aboriginal has affected his or her parents or his or her parents' parents. There are many ways that sharing an Aboriginal heritage can be relevant for sentencing. Some of those ways may be unseen and hidden. It is a judge's role in a Gladue court to shed light on those ways. The other way I find these reports very useful is that the information provided by the sources is often quoted word for word. For example, when Valerie Armitage tells Miss Bolton something, it is sometimes put in quotes. For me, this gives a real sense of what is being said. It is not being filtered or interpreted by the writer. It gives me a flavor of who the speaker is and what the speaker wants to tell me. The best way to get this is if the speaker was present in court telling me the story. Telling me in his or her own words, in a voice spoken with feeling. Therefore, a Gladue report written in this way is a valuable substitute to the speaker coming to the court and saying it in person. I cannot do justice to the details set out in this 23-page report. I can only highlight the main points. I note that much of this information comes from Jessie Armitage's mother. Although Mr. Armitage was interviewed 2 times, he had difficult focusing. Sometimes he was not sure. Sometimes he did not reveal much information even to simple questions. This caused Miss Bolton concern about whether there may be an undiagnosed psychological problem at work. Jessie Armitage is an Aboriginal person. He is not at present recognized as a, quote, status Indian, unquote, under the law, but he could be eligible to do so. He is the youngest of 3 children born to Ronald Moran and Valerie Armitage. Valerie Armitage herself was born in Sudbury, but moved to Toronto when she was 6 with her parents and her brothers and sisters. Mr. Armitage is close to his older sister Crystal in Dustin. He also has a younger brother and a sister through his mother's common-law relationship with Bob. Jessie Armitage himself has a 10-year-old son, but his son lives with his mother. Mr. Armitage has little contact with either son or mother. I have already talked about Mr. Armitage's Aboriginal ancestry through his mother's side. His grandmother grew up on a reserve and was an Indian residential school survivor. Valerie Armitage said, quote, "She went, but she didn't speak about it. She told the stories about what she wanted me to know," end quote. Silence is a pattern seen in many survivors. Much has been written about the experiences of Aboriginal persons who were forced to go to residential schools as children. This has been said by the Aboriginal Healing Foundation. An examination of current commentary on the Canadian residential school system highlights how destructive and damaging the system has been for Aboriginal people past, present, and future. Much of the contemporary discord in Aboriginal communities, such as increased prevalence, rates of substance abuse, family dysfunction, and suicide, have been linked to intergenerational impacts brought about by residential schooling. The policy of such schools set up by the government was to, quote, "kill the Indian in the child," end quote. That policy affected many children and many families for many years. That policy was recognized on June 11, 2008 by Prime Minister Stephen Harper to be wrong. He apologized for it in Parliament. He said, "It was wrong to forcibly remove children from their homes. It was wrong to separate children from rich and vibrant cultures and traditions, that it created a void in many lives and communities. In separating children from their families, we undermined the ability of many to adequately parent their own children and sowed the seeds for generations to follow. The legacy of Indian residential schools has contributed to social problems that continues to exist in many communities today." That policy and experience has affected Jessie Armitage's family. Valerie Armitage, although she hesitated to speak about it, talked about her family's history of alcoholism. "My mom drank. My older sister saw a lot. She took a lot of responsibility being the first child. Having to see my parents drink, fight, see them with their brothers and sisters fighting, partying. And as a teen, my mom drank here and there. Dad drank. She'd leave him under control. When I was a teen, I was old enough to leave the house. I'd be able to just walk out of the house. It did affect my sister. I'm not sure why it didn't affect me. I let it go. I loved my mom and dad no matter what." Valerie Armitage has struggled with alcohol abuse as well until recently. When Jesse Armitage was born, his mother and father separated shortly afterwards. I left his dad and he was still young, a year and a half old. I had to tell him to leave. He was into drugs. Dustin was 3. Crystal was 5. He was a quiet child, then he kind of came out of it. He'd walk in the house and go upstairs. He could not look you in the face, anybody in the face. That's when I started to realize something was wrong. Valerie Armitage raised the kids more or less as a single mother. Jesse Armitage's father was in and out of custody over the years. Jesse Armitage had a difficulty at school, and at the age of 10 he was diagnosed by the school with attention deficit hyperactive disorder. He was given Ritalin, but Valerie Armitage stopped the treatment because she did not believe in it. She contacted the Children's Aid Society around that time for assistance. He was given support by the Big Brothers of Canada and started to play hockey into his teen years. Valerie Armitage formed some common law relationships since Mr. Armitage's father. 2 children came from one of those. Her relationships with these men were troubled. She began to drink again in her 30s. She feared she may have been neglectful to her son Jesse Armitage at the time. Mr. Armitage reported that the last time he attended school was in grade 8. He believes his first contact with the criminal justice system was at 14. When asked why, he replied with, quote, "Not sure," end quote. He left home at 15 and got welfare. He has been on social assistance since that time. Valerie Armitage placed her son in foster care at about the age of 15 when he started to get into trouble. I actually didn't know what to do with Jesse at one point in my life. He was 15. He stole the car in the middle of the night. Then he started getting himself in trouble and charged. I ended up placing him in foster care. Not too long. I felt so guilty. I needed help. Jesse Armitage returned home from time to time, until he got another room in a rooming house. There was trouble at home since he did not work. There was a lot of arguing. When Jesse Armitage was 18 years old, he had a relationship with a woman. At the time, he was working at a warehouse according to his mother. A son was born when he was 19. This relationship lasted for a maximum of 3 years. There is little contact now between them, if at all. The ending of the relationship did not go well as the courts were involved, given Mr. Armitage's behavior. Jesse Armitage, when interviewed, often gave answers that were not particularly informative. However, when questioned about substance abuse, he admitted to smoking marijuana since leaving school a couple of times a week. When asked about alcohol, he said he started at 15 or 16 and used it occasionally. He has not been employed. He has said he had no past romantic relationships. When asked about friends, he shook his head and said no. He could not reply about how he spent his days. He did not know. Valerie Armitage also has had concerns about whether her son suffers from a hidden mental illness. She reports that schizophrenia runs in her family and believes that he might be suffering from this. She told Miss Bolton, "He would have been about 22. He lived with me. He used to come home and be very demanding. He'd be walking around, looking at mirrors, laughing, giggling. He got very angry. He'd be very aggressive with me. He'd never done that. Josh and Brittany were very young. One night, I locked him out. Finally, I called the police. He was saying something, quote, 'I'm ugly, I looked like my brother,' end quote. I'd never seen anything like that. Angry." Valerie Armitage said her son had also seen Dr. Hamlet, but she did not know what for. However, she believed he may have been given medication for a mental illness. Miss Bolton was unable to obtain information from Dr. Hamlet. Valerie Armitage also noted that within the last 5 years, she took her son to the Docus First Nation. "We took him up north about 5 years ago to our reserve, and he got so paranoid. Everyone was around, family, and he had to be driven right home. He started to feel anxious. I offered him, because I take a mild dosage of lorazepam. Nothing could settle him down. He kept walking and moving, saying, quote, 'I want to go, end quote. Mr. Armitage remembered the visit, but he only said 3 short things about it. I visited once a couple of years ago. It was a nice place. I don't know anybody there. Jesse Armitage's mother was also concerned her son may have been sexually abused when younger due to some things he has said. This was just a suspicion she had. Mr. Armitage denied any type of sexual abuse. Although Jesse Armitage said he only used alcohol occasionally, his mother became concerned about his drinking. "I've been on my own for the last 2 years, and he lived with me. He drank every day, every night. First it was beers. He was quiet. He didn't cause problems. Then he started to get a little bit rude, not listening to me. That's when I said, we have to find you a room. He was 100 to 125 to get him through the month. That wouldn't last a week for food and alcohol. He was out there stealing. His brother said, quote, anything you need, I'll get it for you, end quote. He did that for a while. All he knows is he gets a check, he can eat and he can drink. When he runs out of money, his mind goes to where he can get it. He got swept up in the lifestyle again, of stealing. He needs treatment, definitely treatment. It's the top of my list. Treatment and diagnoses. I know that he doesn't do hard drugs. He doesn't have the money and he's afraid to. He's afraid of anything other than marijuana. It's the drinking. He's very dependent on the drinking. At the time of the report, Mr. Armitage was back in custody. He said very little about his circumstances or his offenses. When asked why he was trying to take 2 televisions from a store, he said, quote, to sell them, end quote. When asked what he needed the money for, he said, quote, just for the things I need, end quote. When asked how he spent the money he took, he said, quote, I'm not sure, end quote. Miss Bolton mentioned something that she felt important to write up, which happened on May 1st, 2014, when Jesse Armitage came into contact with his father in the cells of Old City Hall. Joanne Wemi Gomez, the Aboriginal criminal court worker who had spoken with both men that day. She recalled, I felt sorry for this young man. It is easy to see Jesse struggles with mental health but will not admit anything. I went to speak with Jesse because I knew it must have been difficult for him to see his father that way. Jesse was mad at his father for trying to lecture him about his lifestyle and make him feel uncomfortable because he was in front of all the other accused persons in the 116 bullpen. When asked by Miss Bolton how he felt, if he was angry or upset, when he runs into his father in jail, Mr. Armitage replied, quote, everything's fine, end quote. Miss Bolton discussed a number of options, including treatment for drug and alcohol abuse with Mr. Armitage. He showed some interest in some of them. One program run by the Native Men's Residence with a goal to provide life skills to build strong Aboriginal men is talked about with him. Mr. Armitage was willing to give it a try. But when asked about his own goals, he just said, quote, I'll be alright, I'm okay, end quote. Miss Bolton did come up with some recommendations despite the lack of any real long or short-term goals of Mr. Armitage. She recommended if a non-jail sentence was given, 1. Mr. Armitage attend Aboriginal Legal Services to work with the Gladue aftercare worker to complete his plan of care. 2. Mr. Armitage completed an intake with the Anishinaabe Health Toronto with the ability to access a number of services including an addictions counselor, traditional counselor, elders, psychologists, and psychiatrists. Mr. Armitage considered applying for the Sagate and completing the Api Mo Winin. Sagate is a program run by the Native Men's Residence, which is a 63 male bed shelter to house and serve the needs of the homeless in this city. The Sagate's mandate is to build strong Aboriginal men through development of their skills. The first 3 months of the program requires completion of the Api Mo Winin, quote, having confidence in myself, end quote, where each man chooses which learning stream, such as education and jobs, works for him. Mr. Armitage said he would be willing to go, but became uncertain if mandatory part was longer than 3 months. Sagate does have a waiting list. However, the intake interview can be done online and an assessment appointment is done after this. Miss Bolton, the probation officer, and Valerie Armitage all raised the question of whether Mr. Armitage was suffering from a hidden mental illness or emotional problem. This had to be looked into more. So I made an order with everyone's consent for a psychiatric assessment by the Center for Addiction and Mental Health. This took some time to complete. Dr. MacDonald wrote a lengthy report. It is an interesting report. At the end of the day, it would be fair to say that Dr. MacDonald did not know what to say about Mr. Armitage or what to do with him. The doctor also appeared frustrated with Mr. Armitage. Although he had access to much material, he really did not have Mr. Armitage's help or cooperation. He could not, in his mind, decide what was true or what was not given the different stories he had about Mr. Armitage and his past. He did not uncover any previous psychiatric or psychological tests done by him, although Dr. MacDonald believed they likely existed. The doctor did not feel such testing, either in the past or the present, could really be accurately done given Mr. Armitage's indifference and lack of motivation. Dr. MacDonald admitted that his report could only be of limited help. He felt that any treatment would not likely succeed. He was not very optimistic about Mr. Armitage. Mr. Armitage did not seem to have the slightest interest in getting help, changing his life, or obeying any court orders. It led the doctor to highlight this conclusion. Indeed, his degree of indifference with respect to so many things in life is so extreme as to cause me to wonder if there might be an insidious psychiatric disorder present of which I am currently unable to find any direct evidence. Certainly, this has been speculated by numerous others who have known him. If he has a psychiatric involvement of which I am unaware, or any treatment that had any degree of success, I do not as of yet have any evidence of this. There was one recommendation Dr. MacDonald made that I wish to point out now. I do this because it will figure back later in my decision. It will do so for reasons apart from the sentence I imposed. Should Mr. Armitage serve a sentence of some length, he could be referred to the St. Lawrence Valley Treatment Center for a review of his mental condition prior to his release from custody. This is a facility with particular expertise in dealing with individuals like Mr. Armitage, and if he does have a prodromal mental disorder that is simply not sufficiently obvious to detect at this point, it might allow for its appropriate identification and open the door to consideration of treatment prospects that currently do not appear to be at all realistic. So this was some of the information I had about Mr. Armitage at his sentencing. I also had the information about the crimes he committed. I gave him credit for the various time he spent in custody before he was finally sentenced. I carefully listened to the lawyers and what they said the sentence should be. Miss Feinberg was very fair. She understands very well the approach to sentencing Aboriginal offenders. She asked for some more jail time beyond the, quote, dead time, end quote, Mr. Armitage had done. She could have asked for even more, but she did not. Miss Kelly was also very fair. Fair to Mr. Armitage, fair to the concerns I, as a sentencing judge, would have. She argued that Mr. Armitage needed help that he would not necessarily get in jail. However, she understood why the Crown was asking for some more time. There are rules that any sentencing judge must follow, even in cases where Aboriginal offenders are being sentenced. Overall, a sentence must be an individual one. It must respond to the offender. It must recognize the facts of the offense. It has to be balanced and a just sentence. It must protect the community. It must also try to rehabilitate the offender. In this case, I took account of all that I had to. It is not necessary to spell it out. In the end, I found Mr. Armitage's case to be challenging. I found it to be different in ways from other cases I have done. I found it in some ways, sadly, very much the same as other cases. If I could describe Mr. Armitage as a tree, his roots remain hidden beneath the ground. I can see what he is now. I can see the trunk. I can see the leaves. But much of what he is and what has brought him before me I cannot see. They are still buried. But I am sure that some of those roots involve his Aboriginal heritage and ancestry. They help define who he is. They have been a factor in his offending. They must be taken into account in his sentencing. It is also obvious that this tree is not healthy. The leaves droop and appear sickly. It does not flourish regardless of the attention paid upon it. The tree needs healing. A part of any sentence for an Aboriginal offender is to see if there is a way to further that healing of the offender and the community he lives in. One important thing I must consider is the past injustices done to the Aboriginal peoples in this country. How that has affected the present, and how that affected Mr. Armitage, I must also consider the present problem of over-incarceration of Aboriginal offenders. I emphasize that being Aboriginal does not mean that jail can be avoided when jail is required. It does mean that I must consider all other reasonable options before imposing it. Given the pretrial custody, Mr. Armitage has done jail for these offenses. I have concluded that further real jail is not required. I decided this not because he should be treated with mercy. I cannot give him mercy given his past criminal record and how he has behaved while out of custody. A sentence must deter Mr. Armitage. More custody is required for that, although he has pleaded guilty to all these charges. I have come to this conclusion, but also have come to the conclusion that this jail can be served in the community. There will be a conditional sentence order. Of course, there is a test under our law before a conditional sentence can be ordered. I have decided Mr. Armitage has met that test. I know there will be some who will say that given all the times he has failed to respect court orders, that this conditional sentence is wrong. The people who say this might well be right. However, while I cannot give this Aboriginal offender mercy or leniency, I can give Mr. Armitage a chance. Some will also criticize that Mr. Armitage has had many chances, and that he has failed each time. I agree with such criticism, but I believe that we must do in order to be part of the solution rather than the problem is not to stop offering a chance to an offender when it is the right thing to do. This is the best way to be a part of the solution. It is also the best way to protect the community and maintain respect for our criminal justice system. I find that Mr. Armitage appears before me a dispirited man. He has really no self-esteem. He does not think of himself as important. As a result, he does not seem to care about what he does, the harm he has caused to others, the harm he has caused to himself. His spirit has fallen ill. Although I cannot say exactly how or describe it in easy-to-understand words, it strikes me that Mr. Armitage is a metaphor for what negative effects colonization has had on many First Nation people and communities. I have given serious thought to restorative justice principles. I had thought that Mr. Armitage may be the right case for a sentencing circle. He does not seem to understand the harm of his actions. He does not seem to care how his actions affect others or the community. He does not seem to want to connect to the Aboriginal community, the Docus Nation, that defines a part of his identity. But I felt that maybe this type of circle sentencing, if done right, could reach him, could touch him in the right way, put him on the path to health. But here at Old City Hall in Toronto, we are just beginning discussions about having sentencing circles. For a number of practical reasons, such as a process could not be put in place for Mr. Armitage in a timely way. Like everyone else, Aboriginal offenders have a right to justice in their sentence. But justice does not always have to be delivered with a hard, sharp edge. Too often in the past, Aboriginal offenders have only felt the steel when something softer could achieve the goals of sentencing. It is with this in mind that I have decided to order a jail sentence, but one that can be served in the community. The conditional sentence that I imposed is not the end of the journey for Mr. Armitage. I am a realist. Neither is it the beginning of the journey. Mr. Armitage has been traveling this road for some time now. Ultimately, he is responsible for the path he takes while on my court order and the path he takes in life. I have made this order so that he can take this path knowing he need not do it alone. He has the support of others if he wants it. He also has mine. The conditional sentence was for 14 months in total. This is much longer than the actual jail time asked by Miss Feinsberg. I will not go into the details of this order. Mr. Armitage knows them. They include house arrest with exceptions, culturally appropriate counseling, conditions to protect specified individuals and the public, to require him to follow his plan of care, to write apologies to his victims, and to make sure he attend to get into the native program. Finally, I required him to reappear in front of me in a couple of weeks. I did that not because the sentence was not given and finished on the date of my decision. I did it because I care about how Mr. Armitage was doing. There is a postscript to my decision. Mr. Armitage did not make it to his first attendance with me after his sentence. Within days, he was again arrested for doing very much the same thing he had always done. In writing this part of my decision, I first thought I would say that I was disappointed or that it was with sadness that I had to report this. However, I decided against writing this. First of all, it was not unexpected. How could it be? I was only surprised how quickly this happened. I asked Mr. Armitage about that. He had no money. He had little to do. I don't think he really knows why. Even before I passed sentence, I sensed that Mr. Armitage's path along this journey would not be straightforward. More importantly, though, is what happened when he came back before me on his conditional sentence breach. Mr. Armitage asked that 9 months of the remainder of his conditional sentence order be served in jail. He did this so that he could be sent to St. Lawrence Valley Treatment Center. He asked for this because he wanted to be sure he had enough time in custody to fully make use of the help available. This was not something that came from me or the Crown. It came from Jesse Armitage. I add that Miss Kelly was very thoughtful and careful in her representation of him. This will be far the longest jail term that he will have done to date. To be frank, I would have considered something less. Mr. Armitage asked for this because I believe he knew that there was no other way for him to get healthy. I believe that he had come to a point in his life where he was ready for a chance to change. When an offender has come to this point, no matter how long, tortuous, or difficult the path taken to get there cannot be sadness or disappointment. There can only be hope.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.